Okay, welcome back, everyone. If you weren't here for our last session, I am Naima Hawk, a Civic Innovation Associate at Beta NYC, and I have the pleasure of introducing Rachael Fauss here at Reinvent Albany to tell us about opening New York's criminal courts and expanding public availability of decisions in criminal data. So welcome, Rachael, and give her a round of applause.
Hi, everyone. Happy Saturday, happy rainy Saturday. We're glad you're in a nice dry room with us. So I just wanted to introduce myself and Reinvent Albany a little bit. So I'm the Senior Policy Advisor at Reinvent Albany. We advocate for more accountable and transparent New York government. So the open data law that we're celebrating as part of Open Data Week is something that Reinvent Albany was a big part of in getting it drafted, getting it passed. And there's our Executive Director, John, representing. So open data is obviously near and dear to our hearts, and an area that we've been increasingly looking at is, where are there gaps? And we've started to dig in a lot more to court data and the different branches of our government. How does open data and how does transparency relate, not just to state agencies, city agencies, but the different parts of our government, public authorities, the legislature, and the courts. So I'm really excited to introduce the panel here today to talk specifically about criminal court data. So let me introduce my fellow panelists. Terry Ding is a staff attorney at the New York Civil Liberties Union. He works primarily on immigrants' rights, voting rights, and government transparency issues. Terry is a graduate of Harvard College and New York University School of Law. And during law school, he interned at 2 public defender offices in New York City. Oded Oren is the founder and executive director of Scrutinize, an organization that uses data to expand judicial transparency. Before founding Scrutinize, Oded was a public defender in the Bronx for 7 years. Oded graduated from Harvard College and Harvard Law School. And Raelynn Walker, who came all the way from Western New York, shout out to Raelynn, for maybe the longest travel time to get here today, is the Assistant Director of Research and Data Processing at Measures for Justice, a nonpartisan nonprofit focused on bringing transparency and accountability to criminal justice. She focuses on development of Commons, a platform that brings agencies and their communities together to discuss data and the health of their local justice system. And prior to Commons, Raelynn helped develop and publish data for the 20 states currently in Measures for Justice's national data portal, including New York court data. So I wanted to first have us discuss a joint report that Reinvent Albany worked on with Scrutinize that kind of, I think, sets the stage and is a great case study of why court data is a bit different. So I'm going to welcome Oded Oren up to give a presentation about this report.
Thank you. Do I need this?
This one's better than that.
Yeah. Can you hear me? Can you hear me like this? Okay, great. Thank you. So thank you again for having me here, and also for everybody for coming, given the weather and everything. So I'm going to discuss this collaborative report between Scrutinize, my organization, and Reinvent Albany. And I'm going to focus on 3 topics generally. First of all, the motivation, why we wrote about criminal court decisions. Second, the findings. And third, the recommendations. So to start, why is public access to judicial decisions so important? And we want to go a bit beyond just saying that transparency, accountability, oversight are good and necessary for a robust democracy. So let me just go in briefly into the specific reasons for why judicial decisions are so critical in New York. So first of all, judicial assessment. So New York, unlike the federal system, has specific timed terms for its judges. So judges have to be appointed or elected, and at the end of their term, they have to seek reappointment or re-election. And so through data, through decisions, is really the only way in which New Yorkers and decision makers can really assess who a judge is and decide whether they're fit to be reappointed or re-elected. Let me just say one more word about why decisions specifically are so important here. because decisions really are the distillment of what a judge is doing on the bench. Imagine each judge in each case has a world of facts and a world of laws. And that judge has to decide which facts to choose and focus on and which laws to apply and focus on. And they choose those, they use the laws to interpret the facts that they chose, and then they come to a conclusion. And when they're writing a judicial decision, they are laying out exactly their process of thought, exactly what laws and what facts they give value and importance to, and what laws and facts are less important to them. And so you really get to understand how a judge is thinking, what their values are, where they point their discretion, and ultimately how they really conduct themselves on the bench and what the outcomes of their decisions are. The second reason we wanted to focus on judicial decisions was because of legislative oversight. So I'll give here an example from my world, which is criminal justice. So when our legislator passed the very progressive bail reform and discovery reform laws, when those became law, judges at the trial level began interpreting those laws because the law is not always very clear. It leaves room for interpretation, and it's up to the judge to decide how to interpret it in a given situation. And all those interpretations, or at least a lot of them, go into written decisions that then encapsulate how this law takes life in the real world. And so for the legislator who passes these laws, it's really important to see what is happening on the ground, whether the words that they wrote on a page, the intent that came into writing this law and passing this law, whether that manifests at the most basic level of interpreting this law in a court. And the last example is legal insight. So as a practicing attorney, it was really important for me and for my clients that I understand who the judge is, that I know how they're going to rule on specific issues, what arguments are more motivating or influential for them, and what arguments are less so. And that helped me be a better attorney, but it also made the system perform faster and more effectively, right? Because if I know that I have a specific argument to make, but I know that the judge in that case is not going to buy that argument, as a public defender, I might be more inclined to recommend that we take a plea rather than go to trial. And we can save time and money to everybody involved by understanding who our judges are. And so those are the three specific motivations for why we focused on judicial decisions. And I realize this slide should have come earlier, but like, what do we mean specifically by decisions? We mean written decisions, so decisions that the judge sat down, typed into a computer, wrote, and then sent away to the parties in a given case. We mean decisions in criminal courts, because we focused specifically on cases or decisions in criminal cases, not civil cases. And we mean making those decisions published or publicly available. And that's an important distinction here, or definitional term, what is published? Because theoretically, any New Yorker, if they know a specific case number, a docket number, or an indictment number, can go to criminal court, wait in line, ask the clerk for the physical file of a given case, wait to get it, look through it, pull out the decision that you want to read that was printed and put physically in that file, and then you will know what that decision says, what that judge said in that decision. And you would have to repeat that again and again and again and figure out a way how to find all the indictments for all that each judge presided over. It's a long, complicated affair. And so when we are talking about published decisions, we talk about having them widely available online on a free platform. And so findings. So we wrote this report, and the first major takeaway is this, that it's up to judges at the most basic level in the court system, in the criminal court system, to publish their decisions and make them publicly available. So what happens is that a judge writes their decision, they send it to the parties, and then they have a choice to make. They can choose whether to send it to a state body that would then publish it and make it publicly available to everyone through a portal, a searchable portal, or they can choose not to publish it, and then it will just stay in their hard drive, and you will have access to it only if you know the attorneys, or you go and get the physical file where a physical copy was put. So judges control which decisions of theirs become publicly available. Now, because they control these decisions, there is a question of how, if you want to quantify what's going on at the criminal court level, how are you going to figure out how many decisions are out there? How many judges are writing how many decisions? We didn't have access to their hard drives, so we don't know what they save on their hard drives, and the court system doesn't really keep track of that kind of information. I made a FOIL request, I got an answer, they said there was nothing. And so instead, we tried to use a proxy to estimate the number of written decisions. And I'll talk about these findings in a second, but let me just get to the proxy. What we did is we said, we're going to look at all the cases that come into the criminal justice system in a given year, or specifically in a 4-year period. And we're going to look at specific subsets of these cases, the cases that are most serious, or are the ones that are most likely to have a written decision litigated, right? So if you're charged with a very serious offense, it's very likely that your case is going to last for a long time, and that your attorney is going to file some motions that will be later decided in a written decision. And so we took 3 buckets of cases. The utterly most serious offenses, A and B violent felonies, which you can see at the top row. A second subset that includes all the violent felonies, still very serious cases, but slightly bigger bucket. And then we took a third bucket, which was all those violent felonies, along with misdemeanors that have been pending for 180 days or longer. And we can talk later about the legal reason for that, but when a misdemeanor pends for a very long time, it's more likely that there was some decision filed in that case. And so we estimated those buckets through data that the court system made available publicly. And then we just counted how many criminal court decisions were published in this period. The number is not here, but if I'm not mistaken, it's 1,092 over 4 years. And so that's how you get the publication rate. So somewhere between 0.5 to 6% of criminal decisions get published, depending on sort of what bucket or proxy you use to estimate that number. And that means that in a given year, you have between 4,200 and 54,000 decisions that judges sit down and write on the computer and never release to the public. Next, we pulled the names of the judges from the decisions that they did author and did publish, those 1,100 or so decisions. And we looked at a breakdown to see what was the average and median of these judges. And you can see that on average, a judge publishes 2 to 3 decisions annually. The average is probably lower, as Rachael will want me to say, because we were not able to count how many judges were sitting on a bench in a given year and not publishing anything, because the court system does not even put out a list of judges who are presiding in criminal court in a given year. So this is only based on the judges who actually published something in a given year. And the last thing we did was look at sort of the variability between judges. And you can see that on the graph. There is wide variability every year, but sort of consistent, of judges who publish more and judges who publish less. And we also looked at the total number of publications over time. And what we found here is that 3% of the judges, about 20 in the entire state, publish almost a third of all of their decisions. So these judges decide that they want their decisions to be made public They want to be transparent. So they take the decision, they write it, they submit it in the case, and then they email it to the state body on their own, and it gets published. On the other end, about 60% of the judges, or 356 of them, had 3 or fewer decisions published, which again means that they very likely wrote many more decisions, but made a conscious decision not to publish those decisions. And we get into sort of hypotheses in the report of why this is happening. It's not necessarily an attempt to hide anything from the public. There are other reasons. But regardless, what that means is that we cannot know how these judges rule. We can look at 1 or 2 or 3 or 4 or 5 decisions, but we cannot get a better sense of where the judge is and how they're conducting themselves and how they're analyzing the law. And we certainly cannot do a good job in interpreting quantitatively what they're doing. And so based on these findings, we made a few recommendations. We can go into details about that in the Q&A, but basically we said the court system needs to put all of these decisions up online to be publicly available. And the court system should take this sort of opportunity to start publishing more quantitative data that researchers and the public can use to understand better what is happening in our criminal legal system. So what type of decision a given decision is, what the outcome was, and other information. I think that's it.
Thank you so much, Oded. So I think that gives you a bit of an overview of one particular piece of court data and information. And I think it's fair to say that, we're at a panel, this is a panel at a conference about open data, and we're not talking about open data in an easily usable format that Oded had to use to get this information. This is data that was generated by Scrutinize in order to come up with these findings. It wasn't really from an open data platform. It was from the portal of decisions that are currently published. So just to clarify that. So I want to kick it off and talk to our panelists about some broader themes about New York State court data. And we invited Raelynn here in part because they have a national view at Measures for Justice. So I wanted to zoom out a bit and see where New York falls nationally in terms of transparency of the court data. Measures for Justice has a national data portal, and wanted to hear about how New York matches up with other states in terms of criminal court data and court data generally.
Sure. So Measures for Justice kind of came up with this set of what we call performance metrics for how the system is kind of functioning. So how many cases are being filed in a year, and then of those cases dismissed, declined, pled out, and so forth. And so we have like almost 100 measures, I think, and we were only able to publish the 5 boroughs of New York with 8 measures, compared to Pennsylvania, our direct neighbor, who has something like 80. Or that could be overestimating it. But there's significantly more. And so we found that, and this is not just necessarily a New York issue, but it was present in New York, of lack of centralization of how you collect data. So not everybody has direct access to the data that we were looking for. And so unless we were ready to scrape every single county's data or go to every single county and kind of from each of their courts, get data from them directly, which would have been very expensive, very time costly. We kind of had to work with what we had, which was this one system that operated over the boroughs was able to give us their data. The rest of the state is in the dark still. And compared to other states where they're very centralized, we could go to the office of the court administrator and just ask them for like every county in their state and what the criminal courts are up to. And so it was a lot more difficult in New York to get that state level data.
And I think it's important to highlight too that folks may not be aware, up in I grew up in upstate New York, so I can say this. There are very different local and village courts in New York State
Oh, yeah.
than in the city, for example. There are non-attorneys who are serving as judges throughout the rest of the state, and I think it shows that there's a very big diversity of the kind of capacity when you have a decentralized system. The 5 boroughs come out as, having a much more sophisticated process, but still, at the same time, lacking. If even with the data that we had, that Measures for Justice was able to get from the 5 boroughs, it was still less than other states. And then it was completely lacking for the rest of the counties.
Yeah.
That's fair. Okay, and I do want to encourage the other panelists to jump in and build off of each other too, because I think this could be, it's an interesting conversation when we have it together, so. Okay, I want to jump to Terry. Terry, you're currently involved in freedom of information law litigation with the Office of Court Administration. So wanted you to tell the audience a little bit more about that litigation and what it says about court transparency in New York.
Yeah, this case is about, I think, an interesting aspect of court transparency that goes beyond just sort of data. And it relates to a practice that only recently came to light in New York about the way that judges throughout the state court system interact with a state agency called the Office of Court Administration. And as the name suggests, the Office of Court Administration is, on paper, responsible for overseeing the administration of the courts, right? So things like, assigning judges, managing dockets, budgets, training, things like that. But in 2021, it was revealed in reporting done by the New York Focus that OCA goes beyond that role. So it turns out that OCA has a practice of issuing sort of legal memos to judges throughout the New York court system with guidance on how this agency thinks judges should interpret, should apply certain laws or certain court decisions in certain types of cases. And the context in which this came up, I think, is illuminating in understanding why we, the NYCLU, became interested in this and also concerned about it. Because the New York Focus article talked about a specific memo that was somehow leaked to the public addressing a case called Crawford. So in 2021, one of the New York appellate courts issued this ruling in a case called Crawford that was important. It was about the due process rights of people who have been accused of crimes and the process they're entitled to before a court can order, a temporary order of protection against them. And the effect of these temporary orders of protection can be to, keep a defendant from, being in their home or being near their families while they're awaiting trial, which, can take weeks, can take months. And this Crawford decision implemented these important safeguards, right? Like it said, before a court imposes a temporary order of protection, it needs to hold an evidentiary hearing so that it can hear from both sides about whether this order of protection is warranted, is necessary. But within a matter of days, OCA issued a memo to state court judges who oversee these types of cases. And this memo said that courts should resist, and it used that specific word, resist, allowing full testimonial hearings in cases like this. So OCA was encouraging judges not to allow the parties to bring witnesses, for example, who could tell the court about why a temporary order of protection should be imposed or should not be imposed. And this memo came to light through the New York Focus article. And what was interesting is that, an OCA spokesperson was quoted in this article as saying, oh yeah, this is a normal practice for us. Specific words, normal practice. And so we were surprised by that because we didn't realize that an administrative agency, took upon itself to issue, substantive legal guidance to judges on how to, how to interpret the law in deciding cases. So we sent a Freedom of Information Law request not long after, in late 2021, seeking this type of memo, right, this type of guidance. And we've been in litigation ever since because OCA has steadfastly refused to produce a single one of these documents. They don't deny that they exist, right? They've never denied that they do this. They've just refused to produce it. And so we're still in litigation about this, but I think what this sort of issue in this case illustrates is that there are sort of different categories of concerns about court transparency, right? So, as we know from Oded's presentation, the New York court system is this, vast, sprawling bureaucracy, and generates and processes a huge amount of information. And so, sure, I think there are very real logistical challenges to, making sure that what should be, made available to the public is, made available in a full and timely way. But there is also a concern that, in situations like with these memos, the OCA is, making an active decision to keep those under wraps, right, to keep them from the public. And that, that's very worrying for a lot of the same reasons, that Oded explained as to why, the public should be able to see judicial decisions, right? Because if a judge is going to be ruling in your case and relying upon, information guidance that you're not aware of, how are you supposed to make arguments against it, right? If that guidance isn't in your favor, how can you argue that interpretation is wrong or that it should not be applied to your case? And so, we continue to hope that this litigation will get us these documents so that the public can be aware of them and understand the full scope of this, what OCA calls a normal practice. But so far, they've fought us tooth and nail.
Rachel, if I could just jump in, I would just say, Terry said if the judges use it, and I just wanted to say the judges do use these memos. I've litigated cases, and my colleagues in the public defender office have litigated dozens of cases where specifically the judge references this memo or makes a ruling based on this memo. Now we know what's in this memo. So they have a lot of effect. It's not like this is just a piece of paper the judges get in their email, never read, and it means nothing. They actually either cite to it or just rely on it in making their determinations.
I just want to use moderator prerogative and ask a zoom-out question. Would someone on the panel be able to answer, maybe briefly for the audience, why it's different to get these types of memos from the Office of Court Administration versus a state agency, and how it's different under the Freedom of Information Law?
Sure. So I think just briefly about this, the Freedom of Information Law in New York, as a general matter, applies to materials, documents in the possession of state agencies. But the Freedom of Information Law, has a specific definition for what falls under this category of agencies, and that category specifically excludes the judiciary. So you can't just file a Freedom of Information Law request for example, a bench memo that is just circulated within a judge's chambers, right, between a judge and their law clerks. I mean, you can, but it would be denied, and you wouldn't be able to actually get those documents. But OCA itself is an agency. It's not a part of the judiciary in the sense that judges are, and so depending on the type of information and documents you're seeking, you can submit Freedom of Information Law requests to OCA, but there are also certain types of requests that, if you're seeking documents that fall more into the judiciary bucket, then you're probably not going to be able to get them.
I would just say that's really important, I think, for the audience to understand. When you're thinking about open data at the city level, you're thinking about agencies and what data they hold and how that, by that law, it's all supposed to be proactively put online. Whereas we have a very different and interesting distinction, I think, at the court level in New York State, and I just wanted to make sure that everyone understood that. Okay, so going to move on to another question. So Oded, I know another report that you focused on with your group Scrutinize looked at individual decisions of individual judges, and in that report did name some names using some data you were able to get. So maybe you can talk to us a little bit about the questions around pushback from the judges, around judicial independence, and how judge-level data might be a little bit different than that court data that we're talking about.
Yeah. So let me start by just giving some background. The report that Rachael referenced is a report that we put out with a couple of other groups where we obtained data from the court system. They made this data available because of some legislation. And that data has case-level information about all of the incoming cases into the court system, the criminal court system. And so you can imagine an Excel sheet. Each row is a case, and it tells you about the criminal background of the defendant. It tells you about what the charges in that case were. It tells you who the judge was, and then it tells you details about the decision that the judge made at arraignment, basically whether the judge decided to detain the defendant during the duration of the case or whether the judge decided to release them. And so what we did is we built a statistical model that identified those judges who were most likely to order pretrial detention for defendants while controlling for the charges and the background and other information that we had from the data set. And so we released this report. We also named the judges because, again, our position is that judicial transparency means that we, New Yorkers, should know who our judges are, what decisions they're making, and what are their impacts. And so we put that report out, and very quickly, we started getting a lot of pushback from the judiciary. We had 2 former appellate judges write op-eds calling our approach junk science and saying that we interfered with judicial independence and that we were trying to intimidate judges to rule in a specific way in arraignments. And then 12 judicial organizations came out in support of those appellate judges and basically, again, said that we were trying to intimidate them not to implement their oath of office. And so that started a whole conversation, mostly in like legal journals, about judicial independence and scrutiny. And so our position is that, again, to sort of repeat what I said about the necessity of data, of open data, our position is that judges are public servants. They're reelected and reappointed. And just like we want to know what our governor does and what our elected officials are voting on, we should want to know, and we should know, what our judges are deciding and what are the effects of their decisions. And so we did get a lot of pushback, but at the same time, I think, I definitely think that transparency makes sense for judges. I don't think that they are in some way different from other public officials. What I do think is that the pushback illuminated just how insulated the judiciary has been from public scrutiny for so long. They have basically made their decisions and ruled their small fiefdoms, their courtrooms, without any kind of transparency, without any light shining on what's happening there. And now that there is starting to be some light, when we're starting to crunch data and come up with insights about what's happening, they're going to lose that. And I understand why they're pushing back on it. But I think that ultimately for robust democracy, and especially for our democracy in our state, which is built on the system of reappointment and re-elections, you have to be able to see what is happening in there so that you can have the tools to assess and to oversee it as the public and as decision makers.
And just to clarify, the data you used was mandated by the legislature to be released, correct?
Right, that's correct. So the data is basically arraignment data starting in 2020. It was I think it was passed as part of the bail reform package of laws. And so OCA, the same sort of office that Terry and his colleagues are suing, has to put this data out. They don't have a choice about it. Maybe I'll jump to sort of another topic that might be of interest, is that Scrutinize is in the process of litigating freedom of information requests, or not litigating yet. We made those requests with NICLU, with Terry's organization and another organization, to try and get more data from OCA. So basically, OCA was ordered to release data from 2020 moving forward, but they are sitting on troves of data going back more than a decade. And they have released it to some agencies under some confidentiality agreements. They have released it to some academics for asking specific questions that OCA has vetted, but they're not releasing that data to the public, and that's what we're trying to do.
Thank you. So I want to turn it to a different side of this discussion. We've been focusing a lot on what data isn't available that should be available. I think something important that Measures for Justice has looked at that I'd like Raelynn to answer is questions of privacy, in particular because of the passage of Clean Slate in New York State. Measures for Justice has a report protecting privacy without jeopardizing transparency. And, you know, in preparation for this panel, you mentioned to me that some of the findings surprised you in particular. So I'd love for you to give an overview of that report and some of the findings.
Yeah, so as an agency or an organization that collects data on individuals and their cases in the criminal court system, it started to occur to us that we would start losing access to this data as Clean Slate was implemented across the country, whether it's actual Clean Slate by the Clean Slate Initiative, a bill drafted by them, or just kind of some variation of it. We would start losing access to a lot of the national data that we had, and we would no longer be able to see those blind spots that exist because we don't have access to data that we previously had access to. So Measures for Justice tracks from arrest to post-conviction where the data are available. But if they're getting rid of, for a good reason, getting rid of criminal records is a good thing in most applications. As these records go away, we can no longer see an entire half of the system because post-disposition, these records, if it's non-conviction, are going away. And then in certain cases, after a certain amount of years, the convictions go away as well. And so we lose a lot of ability to track things like racial disparities in sentencing, in pleas versus diversions, and anything like that, because the data are just gone. But at the same time, there's this inherent kind of tension between we want access to data because it will help the people that are affected by the data, but the removal of their records is also intended to help those same people. And so how do you deal with that? How do you kind of address that tension? Because individual privacy is extremely important, especially for people who are being harmed by these records that they have. And so going into this paper, we kind of had these preconceived notions about kind of where we fell on the issue. Anonymized data will help people store the data and still remove it at the same time. But it never occurred to us how getting rid of the record actually affects the person the record is about. So if they don't have access to their own record, they need to prove to a court or to somebody that a previous conviction they had does not bar them from something. They no longer have access to that record. Especially if you're somebody who's dealing with immigration and you have to go to a courthouse to get the record like in your hand physically, and they've got ICE standing outside. What are you going to do in that situation as an immigrant kind of fighting for your status? So it was like that kind of hidden spot of we kind of knew where the problem was and what the problem was. And then there's these rabbit holes that just started appearing left and right about, oh, well, this isn't taken into consideration frequently when developing these reform efforts and these policies. And so our paper kind of landed with like, we have recommendations, we also have a lot of questions about how to prevent third-party access to records that were available for a period of time and then were removed by the court but remained public on these third-party sites. And kind of just questions of how to address those pieces of it and still protect both what the researchers are looking for, which is reform that's evidence-based, and what these people are looking for, which is please stop hounding me about my criminal record.
Does anybody else want to jump and add to that? Okay. So I want to turn it back to Terry and give you some space to talk about general efforts of the New York Civil Liberties Union for shining a light on criminal and court data, and ask you a maybe somewhat political question, which is, we have new leadership at the Office of Court Administration. What do you think this potentially means for opportunities for sunlight in our court system?
Yeah, maybe I'll take the second part of that
Sure.
question first. We do have new leadership at the Office of Court Administration. We also have, as of last year, a new chief judge of the New York court system who is also in that role, sort of oversees court administration generally. And I think just anecdotally and as an overall impression, it seems that, Chief Judge Wilson, this is something that Chief Judge Wilson cares about. And I think we also know that Chief Judge Wilson has based on his judicial record, has been quite attentive to the rights of, people accused of crimes. And so I think, there are some promising indications that there's going to be some, internal examination, of practices around transparency. But, taking, our litigation against OCA as an example, it's not as if they've suddenly turned around and said, please take these records, So I think we would still like to see more concrete changes, more concrete movements in the direction of transparency. And I don't think this diminishes the need for organizations like ours to continue to push in different arenas for that transparency. Oded mentioned the FOIL request that our organizations have sent out for more types of data about criminal cases and judicial decision-making. So I think all of that continues to be necessary. And I was I've been sitting here and listening to my co-panelists talk about their perspectives. It sort of strikes me how important these different kinds of transparency are to each other. So for example, the way we found out about these legal memos that OCA sends out to judges is through this report that was this news article that was prompted by, I assume, a fortuitous leaking of one memo, right? But if we had more robust insight into how courts work, how decisions are made through data, that may have been something we could have detected in an indirect way, right? If we're seeing no change in the way that temporary order of protection decisions are made after the Crawford decision, we might be able to sense it. Something odd is going on here because this landmark decision came out and courts still seem to be proceeding as if nothing has changed. So I think all these forms of transparency are mutually reinforcing.
Thank you. I have one more question I want to ask for Raelynn about a project she's working on, and then we'll open it up to the audience. I wanted to make sure to give you space to talk about kind of more community-level data portal that you've worked on. So particularly in Monroe County, in the partnership you've had with the District Attorney's Office, if you could speak about that a bit, that would be helpful.
Yeah, so something we've recently become focused on is getting the community involved in their own transparency and accountability efforts, especially with the agencies that serve those communities, as the people in those agencies are also members of that same community. Monroe County has been a really interesting project because Measure for Justice is based out of Rochester at the heart of Monroe County. So we are also members of that community in a sense. And so there's been a lot of kind of turmoil between these local justice agencies and the community, at least in Rochester specifically, but Monroe County kind of in a larger sense. And being able to kind of step in and allow the community to have a voice in what is being released, what is being tracked, what these agencies are being held accountable for, and kind of getting everybody to come to the table. We've got our community members, we've got our district attorney and kind of some of their representatives sitting around a table together and being like, how can we do better and how can we hold each other accountable in doing better? And we've seen a lot with these new commons projects that people are interested in being transparent, but they don't always necessarily have the resources to be transparent, or they're working against other kind of external factors of, oh, well, we don't track that. There's no place in our system to track misdemeanors, or we're in kind of an outdated system. All of our misdemeanors are in boxes sitting somewhere. I think I once saw in data that they were in a dungeon. So just like these little things of just, there are so many external forces on acting upon data transparency, and it's kind of this question of like, which one do you tackle first? So that's been something that's been really kind of rewarding in working on these sites, and pulling the community in and allowing them to have a voice.
And the portal, one thing I noticed that I thought was very interesting from, coming from a watchdog group, the district attorney's office had an internal goal. They wanted to use diversions more, and that's, getting cases out of the court system, right? So for alternate treatment, like substance abuse treatment. So the portal you created takes their own data and tries to measure it against, that goal, and how are they meeting that goal? And how was that goal developed? Was that a community driven question in terms of how to answer that?
Yeah, absolutely. So MFJ fosters conversations between the district attorney's office and kind of what they think that they can do, what they'd like to see. So that the DA typically has a lot of insight and input into that decision. But it also is in large part a decision with the community advisory board that we put together, where it's not just a decision that the agency is making and saying, this is our goal and this is what's going to happen as we achieve that goal. The community actually can step in and say, you know what, I want you to divert more felonies, not just diversion in general. I want you to divert more felonies, or I want you to kind of look into this or that in your policy goal and your objectives in the coming years. So it's, again, like fostering that conversation and allowing the community to really like talk directly to these agencies and say, we would love to see change in this arena.
Does anyone on the panel have something want to say to wrap up, or something to reflect on another? Okay. All right. I would love to take some audience questions if folks have them. Okay. And if you can use the mic, I think that's helpful so that it can be gotten on the audio recording.
Thank you so much for the amazing discussion here. There's so much I learned about New York's criminal courts that I did not know before. Again, I just want to reemphasize what Rachael said. If you have a question, please press speak on your mic right here and angle it towards you so we can hear you. I guess for my question is that, do you feel that the future of court decisions will be influenced if law mandates that all judicial court decisions have to be made public and open to New Yorkers?
Yes, absolutely. I think that, I will speak anecdotally. I've received a lot of decisions in my years of practice that were not published. Some of them were excellent, and some of them were terrible, not in terms of just the sort of outcome, but in terms of the reasoning and the analysis. And I think that making all of these decisions public will ultimately help improve the quality of justice that is dispensed, and will, make just the system work better.
And And I would just say that this is something we are exploring with Senator Gianaris, who committed to look at this issue with us. So there is something in process. Okay, all the way in the back. Yes, you, if you could turn on your mic.
Thank you again so much. This is slightly a different discussion, but I wondered to what extent any of you are tracking the use of automation in the criminal justice system, and these use of sort of like fraud or risk protection detection algorithms in like the bail system. Is that something that you're seeing at the state level or national level and tracking? And how is it related, I guess, to transparency about the kind of data that's inputted and what we know about systemic racism in those kinds of algorithmic decision-making tools? And if that's not something any of you track, then obviously disregard, but.
I will answer that. We do not track or engage in that conversation so much. We are, part of our Freedom of Information request is to get the sort of outcomes that those algorithms are actually outputting in criminal cases. So we can study them from the perspective of how they influence or not influence judicial decision-making. But we're not looking at what goes into the algorithm. And I know that's like a bursting field in academic research, but we're not there.
Okay, and then, yes, with your hand up. Go ahead, yes. And if you could turn on the mic, yeah.
This question is for Oded and Raelynn. You both mentioned some of the recommendations, Oded, that Scrutinize made about making things more transparent, and Raelynn, you mentioned some of the barriers to making that happen. Are either of your organizations working on, or are you aware of any organizations working on playbooks for court systems, whether local, municipal, whatever level, to make them more transparent and deal with some of those barriers?
So something that MFJ has been working on a lot more recently is allowing our agencies that we work with to kind of self-assess what they already have available in their system, which allows them to kind of see spots where they were very confident something existed and it doesn't. And so we also have worked in the past on legislation for data collection in the criminal court system, the biggest one being in Florida a couple years ago. And so it's something that we're very passionate about as a data organization and a transparency organization of life would be so much better if everybody collected these things and kind of kept track on these things. Because we've found, as we've worked with so many different places, nothing is consistent or standard necessarily, and so kind of having a standard set of data that really should be focused on and tracked allows these agencies to kind of get a sense of, oh, okay, so if I wanted to know how bail reform was working, I would first need to start collecting data and information on bail. And so that has been something that's kind of a large endeavor in our future, personally.
Okay, yes, in the pink.
Wow, I have learned so much, and still I need to learn more. This topic is definitely, it's only the tip of the iceberg. Anyway, the question I'd like to pose is, how could the public, the general public, right, uncover the New York State traditional law, which to me is a blind justice, is actually infringes on our democracy, okay? So what can we do from today on to encourage a little bit more transparency in the city of New York or even Rochester? It is still one state. What can we do collectively? Because this is the only way things would change if, it seems to me, you apply pressure. Because they can only store so much. Eventually, they're going to have to give in. And the public will see a lot of stuff. And I think that's what they're probably concerned about, is how, when the public get a chance to see it, what will our reaction be?
I can take this one. So I don't know so much what the public can do. I'm, less of an organizer, and at this point, I guess more of a data analyst. What I would say is that I am relatively optimistic. I think what we have seen over the last decades is that two trends are happening. One is, I think people are realizing or at least liberals are realizing what the conservative movement has known for a long time, which is who the judge is matters a lot, right? It's not just how the court and the laws operate, it's also who's presiding over a case. And we've seen that play out again and again at the highest level in the Supreme Court of the United States. I think at the same time, with the Supreme Court becoming more conservative, there is a lot more realization that state courts matter, right? Like, I have this line, which is that 99% of criminal cases are actually heard in state courts, not in federal courts. All the eviction cases, all the family separation cases, all of those are happening in state courts. And so what these two trends have done is transform the way, I think, that the liberal crowd understands the importance of state courts vis-a-vis the federal courts. And so I don't know how we get to a point where we have more transparency and more accountability. I have some ideas, nothing systemic. But I think we're getting there because people now understand how important this issue is.
If I could add, I think, we're talking about, obviously the discussion has highlighted how much we don't know. And if we can start to get our hands on answering some of these basic questions about get the data that lets us understand how an individual judge is making decisions, that information could then go to, the press. It can go to advocacy organizations. It can go to political clubs. And then the public can start to have a better sense when you vote for these judges. You can have an understanding of the track record. But right now, I think, who is actually voted for judge in this room in a recent election? Can anyone, okay, we got a few, all right. How many people decide not to vote for judges because you have no idea who they are? Okay, I see some hands. Okay, I saw one hand, both the same, yes to both questions, which I get, because sometimes you know information and sometimes you don't. I think that speaks volumes in that, we don't have any information on the vast majority of the judges, or very poor information. So as a member of the general public, you can't even voice your, opinion on a judge at the ballot box because you don't know the basics. So I think you start with the data, and once the data starts to become available, work with the legislature to help get that data. And then it can get in the hands of the people who can help inform the public, like journalists, like advocacy organizations, researchers, academic institutions. So that's my answer of, I think we have a few steps before we can get the public engaged because we don't even have the basic data we need. That would be my answer. Okay, we have someone all the way in the back.
Hey, thank you so much. This is a very informative panel. To what extent, I think this mostly goes to Raelynn, to what extent do you feel that the resistance towards maybe increased transparency comes from just low data and digital literacy among the bureaucrats who run the OSA, for instance, or the court system? And if you were to come up with interesting use cases for them in a collaborative way, could you create a bit more of a kind of engine of transparency in which, if they understood better how the data they generate could be used even to manage their own affairs, they might be more bought in, and to what extent is then, is it actual systemic resistance towards, any sort of transparency whatsoever?
I definitely do see that elected officials have a concern about if their data are transparent, what will it say about them? Even if it's not bad, they might think the public will find it to be bad, and it's actually a good thing, or the public will believe or see it as a good thing that they're doing X, Y, Z in their system. But one of the biggest forces that everybody is kind of operating against is data hygiene and just poor data hygiene. So if a case management system provider sells their system to a state agency and either doesn't give them training on it or thinks it's clear enough and doesn't need training, now these actors are going in and they're adding things into these fields that maybe those fields weren't intended to hold. So we'll get data and it'll say something like, did this person get arrested, right? And so now we've got the name of the officer in that field, yes, the date of the arrest, right? So it's like this field that seems kind of obvious what it should contain just starts left and right getting filled in with things that it shouldn't contain. And so there's a blindness to that kind of phenomenon of if you're building the system, you have no idea how people are going to use it. And then even within the same agency, you might not be using it consistently unless you talk to each other about how you're using it. And so we end up running into people who like very much want their agency to be transparent, and they just can't because they're working against their own system, they're working against their own poor data hygiene, and that kind of going all the way back to that centralization. So if you're not standard everywhere, then you're basically just creating confusion for yourself, and then also kind of limiting how much you can be transparent with your community, with other agencies that are asking questions about you, and all that kind of stuff. And so it's a lot of like getting on the same page, but it's also working against staffing, resourcing, budgets. Do we have the budget to rebuild our entire case management system and then take interns and throw them at fixing all of this data? And so we were also asking a lot of people who are already very busy going to court multiple times a day, motions and all that kind of stuff, also now turn around, go into your case management system and enter all of this information. That's going to take you quite a long time as well because you've got multiple cases to do it for. And so I think that is actually a very large unforeseen burden in addition to just kind of general resistance to being open and kind of exposing yourself to criticism in that way.
Okay, so we are at time, and I understand we have to wrap up because there's lunch, and I don't want to deprive anyone of lunch. So please check out these reports. They were referenced during the discussion. I think we're going to make this slideshow available, but you can definitely go to the websites of Measures for Justice and Scrutinize, and we did the Q&A. And if you want to contact Oded and I have our emails up here. Our other panelists, maybe they'll let you have their emails too if you ask nicely. Thanks so much.
Rachael did such a great job at closing, but thank you again to our amazing speakers and panelists for this discussion on New York's criminal law courts and like the law surrounding it. I think the people of New York deserve to know what happens in our courts, and I'm excited to see a future like that. It is lunchtime, but feel free to chat with the speakers while you have lunch or, you know, whenever you get the chance. But you can meet us back here at 2:30 for with the OTI for the 2023 New York City Hayes Innovation Prize. But thank you guys for being such a great audience.